All rise. The District Court of Appeal, First District, is now open. Anyone having business before this court, draw near, give attention, and shall be heard. May God save the United States, the state of Florida, this honorable court.
Please be seated. Good morning. We have 4 cases on the calendar this morning. The first is going to be by video from South Florida, and after the first case, we're going to take a break for coffee, and we invite everyone who's physically present here today to join us in the Commons, which is to your right and our left, for coffee. Okay, the first case is Turner versus Miami-Dade County School Board. We've allotted 15 minutes per side. We're ready when you are.
Thank you. I'm Gary Keifitz, representing the appellant Doretta Turner. I'd like to reserve 3 minutes for any rebuttal. Doretta Turner is a school teacher, injured February 14, 2000, in the course of scope of her employment when she fell. Test her neck. She was by the servicing agent, the doctor, who initiated of the baby indicated he wasn't authorized to treat the neck.
Mr. Keifitz, you're fading in and out. Your voice, I don't know whether it's a problem with the microphone there or what it might be, but you keep fading in and out, and we're having trouble hearing you.
They just moved the microphone a little closer to me.
That's better. Yes, thank you.
All right, and I'll speak up. The claimant was referred to Dr. Kelman by the servicing agent, who initiated treatment regarding the back, indicated he was not initially authorized, he thought, for the neck, but then on August 23, 2001, no question that he was authorized to treat the neck. He prescribed an EMG, which was provided by the employer carrier. He prescribed nerve conduction studies, and he also recommended a neurologist. The servicing agent referred the claimant to Dr. Graw's neurologist, who undertook in the course of treatment 3 visits, at which time he treated both the claimant's neck and the back. The judge finds that the doctor understood that he was authorized to treat both the neck and the back, and there is nothing in the records to the contrary that he was not. Following the last visit to Dr. Kelman, the orthopedist claimant was also referred to an alternate orthopedic physician, Dr. Harlan Sharon. He also treated the back, and he provided treatment to the neck, including extensive physical therapy. All of this was paid for by the servicing agent. Dr. Sharon reported that claimant reached maximum medical improvement January 4, 2002, with a 5% impairment to the back and a 5% impairment to the neck. However, during the next years, he continued to treat the claimant both regarding the back and the neck, all of which was paid for by the employer servicing agent. Now, no impairment benefits were paid, and accordingly, at the end of June, some 6 months after the rating by Dr. Sharon, a petition was filed seeking impairment benefits. The servicing agent then did go ahead and pay benefits for a 5% impairment of the back. They did not pay any benefits for the impairment to the neck, nor did they pay any penalties and interest on what was contended to be a late payment. And accordingly, the cause proceeded to pretrial July 28, 2003. At the pretrial, the employer servicing agent stipulated the injuries plural, were accepted as compensable. There was nothing on the pretrial that indicates there was any challenge to the neck. In fact, just to the contrary. You will see on the pretrial, and I attached it to my appendix, and it's also on page 220 of the record, that they say Dr. Kelman is authorized for the neck, Dr. Sharon the back. That was the first indication as to what their position was going to be as to why they were not paying the impairment benefits to the neck. The cause then came out for final hearing January 30, 2006. In the opening statements by the employer servicing agent, they did not address any penalties and interest, as has been claimed. Their primary position regarding non-payment of the benefits, the impairment benefits to the net, was that Dr. Sharon was authorized only to treat the back, therefore he could not testify about the impairment to the net. And then as an afterthought, seemingly, for the first time, 5 years after the accident, they say, and by the way, we don't think there was a neck injury ever in this accident, because the symptoms did not come until about 6 months after the accident.
Isn't that what Dr. Sharon testified to? That
Dr. Sharon was asked to assume if these symptoms did not come for some 6 months after the accident, then would you think there was an injury in this accident? And he said, a neck injury, and he said no. Order was entered by but let me say this, that was based on an assumption, and Dr. Sharon, if you look in the record on page 53, he was asked to rate he was asked regarding the disability to the neck, and he said within reasonable medical certainty, the disability he rated the claimant was related to the accident. So if there was a neck injury in the accident, as stipulated to by the employer servicing agent on the pretrial, and in accordance with the 120-day rule, then the evidence is clearly uncontradicted that the injury for which he's rating the claimant was related to the accident.
Didn't he say that your client had a 10% permanent impairment, 5% of which was related to the lower back, 5% was related to the cervical injury, and that his opinion, the cervical injury, had nothing to do with the industrial accident?
No, I don't.
Okay.
Yeah, no. He was asked a question, if the symptoms came 6 months later, would you say there was an injury in the accident to the neck? And he said no. But the whole issue, and then let me say this, if we did not have a stipulation, and we did not have the 120-day rule, and the judge is deciding this without referring to the stipulation of the 120-day rule, then the judge could find there was no neck injury. But I would suggest, let me move on to point 2 then, dealing with the stipulation. We have a stipulation that the injuries are accepted as compensable. As a part of the injuries being compensable under our law, the accident is the major contributing cause of the injury. That's a part of the stipulation. And there's no question that they didn't understand there was a neck injury, because you'll see they say Dr. Kelman was authorized for the neck. So I would suggest, based upon the stipulation, and I note to the court that the stipulation was approved by the judge. There was an order approving the stipulation by the party. It wasn't the final hearing that the employer servicing agent seeks to just totally disregard the stipulation. Now, we both cited in our brief the Eastern Airlines case that talks about the judge has greater leeway in workers' compensation matters in terms of not accepting stipulations. I first want to note that the Eastern Airlines case was based upon a rule that has not been in effect for about approximately 3 years. Further, in the Eastern Airlines case, there was not an order already entered approving the stipulation, as there is in our case. In the Eastern Airlines case, there was a pretrial stipulation submitted, which had not yet been addressed by the judge. I would also note that in the Eastern Airlines case, that the parties seeking to be relieved from the stipulation raised the issue. They said they want to amend it. They said they want to clarify it. In our case, the employer servicing agent simply disregards it.
Mr. Kiefitz, let me ask you a question about the argument that the employer makes to the effect that Dr. Sharon was not authorized to treat the neck injury, and therefore he shouldn't have been permitted to testify about it. Is it your position that to the extent they did in fact stipulate that the injuries were compensable, that relieved any obligation you otherwise had to present proof?
That's one aspect, but let me say this also, that in terms of Dr. Sharon's ability to testify, he is a treating physician.
But he was only authorized to treat for the lumbar condition.
Okay, well, let me say this. The court, no place in the statute is that issue ever addressed. And the court is not going to address that either. You know, we have a very unique kind of statute that says only certain kinds of physicians can testify. That already is very unique compared to the common law. And are we now going to try to limit it? And if so, I'd ask the court, I'd like to know how in terms of the parts of the body. Are we going to do that? I mean, we're going to say, well, he's authorized regarding the L4, L5, but not the L3, L4. When they talk about that, the low back, where does it end? I don't know of any rule, and this law has been in effect since 1994. I don't know of any rule that has ever, said that the treating physician is only limited to testifying about that, whatever he was authorized to treat. And I don't think that's a possibly workable rule. The last aspect in terms of whether we can set aside a stipulation that I didn't get to is under the Eastern Airlines case, only and under the old statute, under the old rule, only where the stipulation is manifestly contrary to all the evidence. Now, in this case, that's not the case. Yes, there's some evidence that would support de novo a determination as a non-relationship. However, the claimant testified, I hurt my neck in the accident. And I told the doctor I hurt my neck. That's evidence supporting the claimant's contention. Dr. Sharon testified on page 53 of the record, without equivocation, the impairment he rated the claimant of 5% is for the injury in the accident. And so I would suggest that based upon the stipulation, that the judge is clearly wrong.
Mr. Keefe, you're down to almost 3 minutes, but let me ask you one question, please. With regard to the stipulation, did you argue in a manner that the JCC should have understood at the hearing that the stipulation barred the employer from contesting compensability of the cervical injury?
Well, yes. I mean, if you look at in the record, I talked about the stipulation where they stipulated that the injuries are compensable. I mean, in opening arguments, the question was, how much do you go and how far? But there's not the slightest question that I specifically discussed it. And when I sit down and look and get the page number of the record, it's not that long, but it's right there.
Is it your recollection that the JCC actually ruled on the applicability of the stipulation in the merits order?
No, I think the judge ignored it. The judge just ignored it. And
okay.
That's my own point. I don't think he can. I will rest on my brief on the matters that I haven't covered, and I'd like to reserve 3 minutes for the
You've actually got about 2.5.
Okay, thank you.
May I please report? My name is Kimberly Fernandez here on behalf of the Miami-Dade County School Board. I'm here to argue that the cervical condition was never accepted as compensable and no treatment was ever authorized for the cervical condition. The cervical was investigated under this claim because the school board did the right thing.
Ms. Fernandez, I'm sorry, let me stop you. We've got 2 problems. The first is you might want to move the microphone a little closer again.
Okay.
And the second is, I need to ask you, have you filed a notice of appearance in this case?
I covered that with the deputy clerk prior. Apparently there was an oversight, and I am not listed on the notice of appearance. My boss is, Stephen Cronenberg, and I'll be doing that immediately following this.
Great, thank you.
No problem. Back to my argument regarding no treatment being authorized. Dr. Kelman first mentioned the claimant's cervical complaint and the fact that they were not raised to him until more than 6 months after the injury occurred and after he became treated. He suggested an investigation in order to determine if it was a compensable condition, and the carrier followed through and allowed that investigation. Chapter 440 allows for such an investigation in order to determine if a condition is compensable.
Ms. Fernandez, I'd like to focus you, if you don't mind, first on the argument that the pretrial stipulation where your clients answered yes in response to the question whether the injuries or conditions were accepted as compensable, why that doesn't bar you from claiming either before the JCC or here on appeal that in fact they're not compensable.
It does not bar such an argument because the pretrial form itself, as you can see, does not parse out conditions or body parts. It merely asks a yes or no question regarding compensability of an injury or condition. And this was a compensable case, and still is a compensable case. The claimant is entitled to treatment for her compensable lumbar injury.
But Ms. Fernandez, I'm sorry to keep harping on this, but the question is phrased in the plural, injuries or conditions, plural. And it's clear from other parts of the pretrial stipulation that everyone understood that there were both lumbar and cervical claims being made. And yet you, and I mean by you, on behalf of your client, didn't differentiate between the lumbar and the cervical injuries. You said they were all accepted as compensable.
With all due respect, Justice Webster, I do not believe that number 7 of this entire pretrial, which is a few pages, would constitute a stipulation to an entire condition that was raised later on in the claim by the claimant when all of the other evidence is manifestly contrary to that and was presented to the judge at trial. And I'd like to point to another position taken in the pretrial just to make that point. That being where Dr. Kelman is indicated Dr. Kelman and Dr. Sharon authorized for lumbar spine only. Chapter 440, as I said, allows for investigation into conditions to determine compensability. So, yes, the carrier did pay Dr. Kelman for that investigation, as well as Dr. Gross. Does that mean that they were stipulating or agreeing or buying, per se, the condition? No, they were investigating.
Ms. Fernandez, let's assume that perhaps there's room for debate about whether this stipulation is binding or not. The other problem I have is the JCC made no findings regarding this stipulation. At a minimum, shouldn't we send it back for findings as to whether this stipulation is binding, and if so, what its impact is?
My answer to that question would be no, and mainly that is because of the Eastern Airlines versus Griffin case, which allowed the judge to reject or ignore a stipulation when the evidence is manifestly contrary to it.
But we don't know here that that's what the JCC did, do we?
We don't know if he chose manifestly contrary evidence over the pretrial. I would say that by his ultimate findings, he did.
Does he even mention the pretrial stipulation in his order?
I will agree with you that he does not. But he does mention his decision to choose doctor opinions over other doctor opinions, which he has the ability to do. And he chose the opinions of Drs. Kelman and Gross over the opinion of Dr. Sharon when it comes to a compensability issue on a cervical condition. It is his prerogative to do so as a JCC.
Would you agree with me that if in fact this stipulation was intended to impart the position that both injuries were compensable, that would have relieved the claimant of any obligation to present any evidence regarding causation?
No, because the law still would require the claimant to prove major contributing cause under the Closet Maid versus Sykes case.
Even if you concede that the condition is compensable, and there's only one, I mean, we're only talking about a lumbar and a cervical condition, we're not talking about exacerbations or anything like that.
It is our position that if the JCC would have, or if this court decides that the JCC should have found that the cervical condition was compensable, that the record is still void of the claimant's proving major contributing cause, and it is the claimant's burden to do so. Because a condition can manifest itself as a compensable condition, but when investigated in light of other conditions or in light of the facts of the case as to when when symptoms are reported or objective testing results, the major contributing cause factor can wax and wane and change over time as the evidence is presented. And as the evidence was presented in this case after Dr. Gross's testing, after Dr. Kelman's testing, major contributing cause was a problem for the claimant, but was not resolved by the claimant in their proof.
Had you received all of the information from Dr. Kelman and Dr. Sharon before the pretrial stipulation was prepared?
I'm checking dates. Based upon the date of the pretrial, it appears that we would have had the opinions that we needed to make our arguments on paper, but we may not have had the depositions taken. But the depositions weren't a surprise to us. We knew from the documentary evidence what they would present in testimony. Aside from the stipulation, well, really, I've made an argument regarding competent substantial evidence supporting the judge's decision to reject the cervical injury as a non-compensable condition because of Dr. Kelman, Dr. Gross, and Dr. Sharon's opinions in total.
Can I direct your attention next to the argument regarding interest and penalties on the lumbar condition? Are you seriously contending that those were timely paid?
I'm not contending that they were timely paid, Your Honor. I'm contending that the evidence in the record does not present enough information for the judge to make that decision.
Well, didn't Mr. Cronenberg send a letter to Dr. Sharon that contained enclosures indicating that at least by March 29th of 2002, Mr. Cronenberg knew that Dr. Sharon was of the opinion that there was a 5% work-related permanent impairment to the lumbar spine?
That is correct. That is in the record.
And the payments for the lumbar spine were made when for the impairment?
I believe in June or July of the same year.
Would that be timely?
That is not a timely payment. The statute allows an exception to timely payment with regard to conditions over which the employer carrier has no control. I am not standing before you to add to the record on that matter. I do not know for the timing of the payment. However, the statute allows for such an exception, and that was not investigated or included in the findings on the record either.
And the burden is on whom to establish the existence of such an exception?
The statute is silent on that. Actually, the statutory provision, section 440.20, subsection 6, is a long paragraph which places a certain burden on the claimant, a certain burden on the judge, and no burden explicitly on the employer carrier.
Is there case law from this court that suggests that it's the employer carrier's burden?
I do not know of any, Your Honor. I believe the court has been silent on the matter. I do know that there is case law which says that the obligation to pay such impairment, and when it became due to pay that impairment, is necessary in order to make a finding regarding the proof of whether penalties and interest is owed. That case law did come from this court in 2001, B&L Services versus Coach, USA. I would contend that that case most would require a remand to the judge for a finding on the issue, because the record at this point does not contain all of the evidence necessary.
So, counsel, you have no response to the Dollar General case cited in the reply brief by the appellant for the proposition that the burden is on the employer carrier to offer evidence it was unaware of the date benefits were due. Page 3 of the reply brief.
I disagree with that holding fits with our position in the case. Because, yes, it may be the employer carrier's burden to determine when benefits are due, but that doesn't also fit under statute 440.2, subsection 6, with regard to proving up conditions over which the employer carrier had no control. I see those as two separate points, there's two separate manners of proof.
So do I understand that you disagree with the Dollar General opinion, or you somehow say it doesn't apply here? I'm a little confused about your response.
I do not disagree with it, Your Honor. I believe that it is distinguishable from the particular question or burden that you are asking me about with regard to the employer carrier. I agree that the employer carrier has the duty to terminate benefits, and that is indicated by the memorandum Dr. Justice Webster referred to from Steve Cronenberg with regard to the impairment rating from Dr. Sharon. I have made all of my points in my argument. If the court has no other questions, I will rest.
Thank you. Mr. Kiefitz, you have about 2.5 minutes, sir.
All right, Judge, thank you. First of all, let me direct you to page 20 of the record. You asked about whether I discussed the stipulation before the judge, and there it is on page 20 of the record. I talk about on the pre-trial stipulation, you'll see the injury is accepted as compensable, and it says yes. There's no attempt at differentiation between the neck and the back. I'm not going to read through everything else, but it is explained at length to the judge. Regarding the issue of the interest in the penalties, the McCoy case holds, in accordance with the general rule announced by this court in the Armstrong case, that he who asserts the applicability of the exception has to submit proof in regard to that. And as a matter of fact, there is proof in regard to that. There's the March 02 letter to the attorney that talks about the 10% rate.
So Mr. Kiefitz, your position on penalties and interest would be that at a minimum, they're due from whatever the applicable date is forward from March 29th?
Well, the applicable date is easy to ascertain. The stipulation on the pretrial. Claimant reached maximum medical improvement January 4, 2002 with a 5% acknowledged to be due impairment of the back. That's what they stipulated to in July of 2003. That's when the benefits are due. What they are arguing is, well, maybe we're under an exception because who knows when we knew about that rating. Well, the fact of the matter is they have to show when they knew about the rating. But we know from the record they at least knew about the rating in March. And look at the record on page 70, which is the doctor's rating report, and you will see it says fast workers' compensation. They knew about the rating at that point in time in January as well. But in any event, they at least knew about it in March by their own admission, and they owe the benefits. They owe the penalties and interest. I didn't get a chance to talk about the 120-day rule. The three cases that deal with, the recent cases that deal with that, whether you take the concurrent opinion or the majority opinion, they all talk about when they haven't responded to the 120-day rule that there is an injury. And in this case, the only injury that Dr. Sharon rated, according to his testimony, with reasonable medical certainty, was the injury in the accident being 5%.
Thank you, Mr. Kiefitz. Thank you both. We'll be in recess. We invite those of you who are here to join us for coffee in the in the commons area, which is through the doors to your right. We'll be in recess.